All right, you may proceed.
Okay, so by stipulation, the defense has here Defense Exhibit 5. It is a report from FBI Agent Hipkiss, who has already testified on behalf of the state, and parts of it have been redacted, and so we want to introduce that. And we understand the state has a document that they want to introduce for impeachment purposes in conjunction with this, and we're not going to object to that.
I've already gotten Defense 5. That's
Oh, right. That was never actually introduced, and so we had marked it already, but we're now introducing it.
Okay, all right, I see that now. All right.
That was just he authenticated it when he was on the stand.
Can you make it clear that's a redacted version of?
Yes, this is a redacted version of what he authenticated.
Any objection, Ms. Ross?
No, Your Honor. The state doesn't believe that they'd be evidentiary burden for that, but we trust the fact finder to give it the weight that it is due. So we have no objection to that. We do have a rebuttal to Defense Exhibit Redacted 5, and I would introduce the documents at this time, and also the rebuttal will be some testimony from Special Agent Beyer, and he'll be playing portions of Diego Ibarra's interview for the court. So I have those items marked. So if the defense wants to rest, then we can start rebuttal. And I'll introduce those documents at rebuttal and tell the court what numbers they are, and the numbers of the documents that, pursuant to these individuals' attorneys, need to be filed under seal, or the request of these attorneys, they need to be filed under seal.
With the admission of Defense Exhibit 5, the rest.
5 is admitted. All right, we'll move into the rebuttal. You all are welcome to stay. I appreciate you being here, but you don't have to.
Thank you.
That's entirely up to you all. Tell me your name again.
I'm Elizabeth.
Okay. Thank you. I know Mr. Everhart. Thank you. All right, you may proceed.
In rebuttal, Your Honor, the state calls Special Agent Lucas Beyer. And in rebuttal, pursuant to our discussions at the bench, and just now, the state's going to move to admit State's Exhibits 330, 331, and 332, and pursuant to the request of the inmates in question, the state would request that these documents be filed under seal after they are reviewed by the fact finder in this case.
Any objections? No, sir. They're admitted. 330, 331, 332.
Yes, sir. And would you like the state to prepare the sealing order, or does the court have sealing order? Okay.
We'll see.
It looks like y'all have it covered.
Okay.
All right. May I proceed with the witness?
Yes.
Raise your right hand, please, sir. Do you swear or affirm the testimony you will give today will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
If you could please take seats, state and spell your first and last name for the record.
My name is Lucas Beyer, Lucasbeyer.
Where are you employed?
I'm employed with the Georgia Bureau of Investigation.
And are you the same Lucas Beyer that has previously testified in this case?
Yes, ma'am.
I want to talk to you about a few things, and if you could, for the record, do not mention any names of federal inmates, okay?
Yes, ma'am.
If you feel like I ask you a question that requires you to do that, I'm going to ask that you pause before you answer the question so that the attorneys can take it up with the judge at the bench, all right?
Yes, ma'am.
All right. We talked last time you were on the stand. We're not going to repeat any of that, but you told us, well, let me put it a different way. At some point, did you receive information from federal inmates about a statement that Diego had made?
Yes, ma'am.
And did you investigate that?
I did.
And were additional inmates, including Diego, the cellmate, interviewed about that statement?
Yes, ma'am.
And were any of the other inmates that you talked to, were any of them able to corroborate that statement?
No, ma'am.
And in the statement that Diego allegedly made to a federal inmate, did Diego confess to killing Laken Riley?
No, ma'am.
Did Diego say he killed Laken Riley?
No, ma'am.
Did you also know that the inmates at that particular federal facility are issued tablets?
Yes, ma'am.
And what's a tablet?
A tablet is a computer similar to an iPad or a Microsoft Surface.
And on those tablets, are the inmates able to access the internet?
Yes, ma'am.
And the particular indictment in this case, in the case of Laken Riley, does it mention the weapon that was used to kill Laken Riley in the actual indictment?
Yes, it does.
And how does it do that?
One of the counts dictates or states that Laken Riley was killed by the use of rocks.
And is that information widely out there in the public?
Yes, ma'am, it is.
I want to ask you about your interview with Diego Ibarra, and now we're going to talk specifics. What date did you interview Diego Ibarra?
Friday, February 23rd, 2024.
What time did your interview start, and what time did it end?
The interview started at approximately 5:13 p.m. It lasted for 91 minutes, and the interview was terminated at approximately 6:43 p.m.
Was your interview recorded?
It was audio and video recorded.
Who was in the interview room with you?
Special Agent Ashley Isaacson, also of the Georgia Bureau of Investigation, and Immigration and Customs Enforcement and Removal Operations Officer, otherwise known as ERO, Officer Wagner Machado. Officer Machado acted as a translator from Spanish to English and English to Spanish.
And in your interview with Diego Ibarra, I'm going to play just portions of it for the court, and the council's welcome to play whatever parts they'd like to play. But we're going to clip this 91-minute interview to about 3 clips. I want to talk to you about, we're going to play these 3 clips, but before I talk to you about them, do you recognize, or before we play them, recognize states 329?
Yes, ma'am, I do.
What is it?
That is a thumb drive that contains clips from my interview with Diego Ibarra.
The city of Utah, 329, and request permission to publish.
No objection.
329 submitted.
In your interview with Diego Ibarra, did you ask him if he had anything to do with the murder of Laken Riley, basically?
I did.
And what was his response?
He said he had nothing to do with it.
And does he tell you where he was at the time that she was murdered? You ask him that.
Yes, I do.
And what is his response to you?
His response that he was sleeping in bed.
And were you ever, in all the hours that you spent, and let me just ask you this, how many hours have you spent investigating the murder of Laken Riley?
Hundreds.
And in the hundreds of hours that you have spent, what about your colleagues who are working this case with you at the University of Georgia Police Department and at the FBI? So Sergeant Norris, Sergeant Rabu, and Special Agent Hipkiss combined. How many hours have y'all worked?
It combined is thousands of man hours that have gone into this investigation.
And in the thousands of man hours that have gone into this case, have you been able to find any evidence that contradicts Diego Ibarra's statement that he was at home at the time?
I found no evidence to contradict the statement that he was at home at the time.
I'm gonna go ahead and play clip 1 for the record.
Wednesday, I started work at 4 in the afternoon. I'm supposed to have started at 3, but I didn't have a ride. I have a friend that sometimes gives me a ride. I didn't have a ride, so I got to work at.
And I need to stop you right there, clip 1. Is that ERO Machado that's speaking?
Yes, that's correct.
And he starts with Wednesday. So what day of the week was February 22nd, 2024?
That was a Thursday.
So when he says Wednesday, he's talking about now the 21st.
Correct, he's talking of the previous day.
And if Laken Riley was killed on Thursday, then the following day when Diego Ibarra and all of the Ibarras are identified, that would be Friday?
Correct.
Thank you.
4 o'clock on Wednesday. Okay, so el miércoles usted entró a las 4 entonces. Sí.
And his work still usually done at 11?
Y entonces el miércoles usted acabó de trabajar a las 11.
A las 11 de la noche.
Oh, yes, 11 at night.
Then after work, where did you go?
Y después del trabajo, el miércoles, ¿dónde fuiste usted?
En la casa, porque nosotros no conocemos a más nadie aquí, no tenemos más ningún conocido. Nosotros somos nosotros y más ningún conocido así.
Okay. So we went straight home. I went straight home. We don't know anyone around here. We're just united together, and we don't know many people around here.
Okay, what time did you get home?
¿A qué hora llegaste a la casa el miércoles?
A las 11, porque ese es el horario de salud.
No, usted salió a las 11. ¿A qué hora llegó a la casa?
A las que me echó media hora caminando, 11:30, casi a las 12.
So, he walked, so he said he got home 11:30, almost 12 o'clock.
Okay, when you got home, what did you do?
Cuando usted llegó a la casa, ¿qué hizo usted?
Llegué a reposar un ratico y esperar que el cuerpo se me enfriara para meterme a bañar.
So he got in and just rested for a little bit, and then took a shower.
Okay, who was home when you got home?
¿Quién estaba en la casa cuando usted llegó?
Estaban ellos, porque ellos salen más temprano, los hermanos míos. Ellos salen más temprano, ¿entiendes? Yo soy el último que salgo ahorita en este horario.
So it was them at the house. My brothers were there because I'm the one that gets home the latest. So they got home earlier than I did.
They were all there?
Todos sus hermanos estaban en la casa.
Sí, todos estaban allá en la casa ya.
And then what time did you go to sleep?
¿Qué hora que usted fue a dormir?
No, yo me pongo a buscar el teléfono y no te puedo decir qué hora porque me pongo a buscar el teléfono, a escribirle a mi familia, a mí.
Sí, pero más o menos.
No, ni idea, porque para tú sabes cuando uno se queda dormido, uno se queda dormido, uno no ve la hora, ¿entiendes?
Okay, so he said I want to be able to tell you the time because when I get home, after I do what I do, I get on the phone, I'm playing on the phone, talking to my daughter, and just fall asleep. I can't tell you the time that I fell asleep, but I just fall asleep.
Okay, would it have been, he can't give you a range, was it a couple of hours after he got home, or had the sun come up?
Entonces, cuando usted fue a dormir, dame más o menos, ¿se fue algunos minutos, algunas horas, o ya salió del sol?
No, tampoco así.
Nada.
Como más o menos más o menos me fue contando como a la 1 y pico, algo así, porque.
So if I had to guess, I would say probably 1 o'clock, one and some change.
Okay, and then what time did you wake up?
Y
Yesterday.
¿A qué hora es que usted despertó ayer?
Ayer que miércoles.
No, ayer fue jueves.
Sí, bueno, ayer desperté que como casi me paré tarde porque me pararon, pero los hermanos míos me pararon que como a las 2:00
A las 2 de la tarde.
Sí.
A las 2, ¿tu hermano? ¿Cuál hermano?
El men y la gorda.
Te despertaron.
Sí, porque ellos se estaban alistando para irse a trabajar y ellos me pararon, no, no venía a trabajar.
Okay.
Era tarde.
So yesterday, his sibling woke him up, Manny and the fourth one woke him up, he said it was around 2 o'clock. They came and woke him up.
So you were asleep from about 1 o'clock in the morning until 2 o'clock in the afternoon?
Entonces usted estaba dormido más o menos de la 1 de la mañana hasta casi las 2 de la tarde el mismo.
Does that complete the first clip?
Yes, ma'am, it does.
I'm gonna play published clip 2 from the 29th.
So we're about to show you a video, and we want you to tell us who you think the person in the video is, or if you know who it is.
Vamos ahorita en este momento.
Because it's difficult for us to see what video is he shown at this time?
Special Agent Isaacson shows Diego Ibarra the video of Jose Ibarra disposing of a jacket in a dumpster.
Entonces enseñarle un video y queremos saber si usted conoce quién está en ese video.
Is that okay?
Yes.
Okay. Do you know where this is?
¿Sabe dónde es eso?
Ya.
Yes.
Who is this?
¿Quién es eso?
Ese es mi hermano, veníamos, nosotros estábamos los juntos ese día.
That's me and my brother. We were both together that day.
Okay, there's only one person in the video, so who is that?
En el video solamente tiene una persona. ¿Quién es?
Is that you or your brother?
Sí,
¿Es usted o es su hermano?
no, es de él.
It's him.
Him?
No, it's his brother. Sorry about him. His brother.
Okay, I'm gonna rewind it and let him watch it again.
Usted va a ver otra vez.
And where is this?
¿Dónde es eso?
Ese es el basurero donde nosotros vivimos.
It's in the trash can or the back over there by where we live.
No, ese está pegado, no está.
He said rewind.
Yes, I did. Just give it a second.
Dame un segundo.
You'll still see him walk. Is that his hat?
¿Es la gorra? ¿Es su gorra?
Sí, es mi gorra.
Yes, it's my hat.
Okay, does he know what his brother is doing?
¿Sabe qué está haciendo su hermano?
Yo me estaba botando la basura. Yo sé, ahí que está botando la basura.
Looks like he's throwing something in the trash.
Okay. And how does he know this is Victor?
¿Cómo que usted sabe que es su hermano? Víctor.
Porque ahí esa ropa yo se la vi a él.
Because that's him in that clothes.
Claro.
Okay. Are these clothes that only Victor wears?
Esa es la ropa que usa Víctor. Nada más.
Esa ropa que en vez de todo para su trabajo y todo.
And that's the clothes that he wears to work and everything.
Okay. And I'm gonna show him one more picture. Or yeah, he's gonna show him one more video to see.
One more video for you to look at.
Otro video para ustedes, mira.
I'm gonna let you watch it, then I'll ask some questions.
Usted va a ver el video, después va a hacer algunas preguntas.
Based on that,
Ese video era atrás de la Roma del autobús.
What video now are you showing at this point at 6:19?
I'm showing Diego Ibarra the video of Jose Ibarra at the bus stop near, or at Rogers Road near Building S.
So this is a different video than the one you just showed.
It is.
The videos in the back where we take the bus.
That's at the bus stop?
¿Es en la parada de autobús? Yes.
Can you tell who that person is?
¿Quién es esa persona?
Ese es el hermano mío.
That's my brother.
Claro.
Is it
Of course.
Sí, ya lo van a reconocer yo mi hermano.
He said, of course, that's my brother Victor. I know, I recognize my brother Victor.
Well, how does he know?
¿Cómo que sabe?
Porque esa ropa es la misma, esa chaqueta es la que tiene en la casa.
Because that's the jacket, that's the
Sí,
jacket he
esa
has at
es
home.
claro. Ahí sabe yo como mi hermano.
And
I know, that's my brother.
he has a little bit of a mustache too?
Does he know why he has gloves on?
¿Usted sabe por qué él está con guantes?
Yo también uso guantes, yo me consumido también.
Eso es la pregunta. ¿Sabe por qué él está con guantes?
No sé por qué está con guantes el frío, me imagino yo.
I don't know why he's with gloves, the cold, I imagine that.
Does he sometimes bring clothes home from work, from the Chinese restaurant?
Cuando está allá trabajando en el restaurante de él, ¿él viene para casa con guantes? ¿Sí o no?
Sí.
Yes.
Describe the gloves that he usually brings home.
Describe las guantes que trae para
Son lo mismo que yo tengo metido en mi mochila, son esos.
It's the same one that I put in my backpack, the same ones. Yeah.
This backpack that you can see Victor carrying, is that his bag or is that yours?
Esta mochila ahí que está con Víctor ahí, ¿es la mochila de Víctor o es suya?
No, esa es la de él, esa no es la mochila mía es la de atrás.
Is that your gray backpack or is that his?
Esta mochila gris es tuya o
Esa es su mochila. Yo la mía es así, pero yo la mía es de espalda.
He said, okay, mine is a backpack. I don't know what he's looking at there. He said that was not, but his is gray as well.
That's a bag that kind of goes across your body?
Signo de lado.
La mochila que usted trae
De espalda.
de espalda y de Victor tiene.
De lado.
De lado. Victor wears a backpack that goes across the body.
Has he seen Victor with that bag before?
¿Usted ha visto a Victor con esta mochila antes?
Sí, claro, la tiene en la casa.
Yes, of course, he has it at home.
How often does he carry it?
Tiene sus cosas ahí metidas.
¿Qué tan pronto él trae esta mochila con él?
No, tiene tiempísimo con su mochila.
Él lleva la mochila cuántas veces por día, por semana.
Ahí tiene todo, sus cosas, su cédula, todo su vaina, ¿entiendes? Su colonia, tiene todo ahí metido.
Entonces él trae la mochila todos los días.
Claro.
Okay, so he's with the bag every day. He carries all his personal items in that bag.
Is that bag in the apartment right now?
Esta mochila está en los
En el
apartamentos
apartamento que
que
está en la casa.
Yes, it's at home.
Where?
¿Dónde?
En el apartamento donde vivimos nosotros.
In the apartment where we live.
Where is that?
Does Victor have a bedroom where he keeps that bag in?
Él tiene un cuarto donde él deja
Vivimos
esta
todos,
mochila.
un solo cuarto nada más vivimos todos.
We all stay in one room. We all stay in one room.
Claro,
One room
dos
that we stay together.
Dos camas, una de dormir la gorda y el otro menos mío, Giancarlo en un mueble y yo viví todo junto.
¿Cuántas camas entonces?
Dos camas y un mueble.
Okay, so he's saying two beds, and I think he's saying what's it called, futon, el mueble.
Mueble.
Sí, con un sofá que se abre,
Sí.
con cama.
Yeah.
Okay, so he's saying like a futon and two beds.
So if we walk in the front door, like guide us to where Victor's belongings would be.
Entonces, entrando por la puerta de la frente, guíanos para donde, vámonos para la izquierda o derecha, para cómo entramos, guíanos para llegar a esta mochila.
La mochila en mano, ahí pueden entrar en la puerta y todas las cosas, nosotros no tenemos nada escondido porque no somos delincuentes, como le digo, ¿entiendes?
Sí.
Todo está en su sitio, no somos delincuentes para estar escondiendo nada, ¿entiendes?
No, pero la mochila va a estar donde, ahí se
Ahí
de la
está,
puerta.
sí, ahí tiene que estar montada arriba, donde duerme, donde dormir, si no está en la cama, tiene que estar ahí donde está toda mi ropa, donde está toda mi pertenencia, ahí tiene que
Entonces, explícame, entrando por la puerta, ¿dónde va a estar esta mochila?
Si no está en la cama, tiene que estar en la pertenencia donde yo tengo mi ropa doblada.
No suya, de Víctor.
Que todos somos hermanos, todos están juntos.
Okay. So he said, coming in, if it's not right there on top of the bed, it's gonna be by their stuff where they keep their clothes next to the bed somewhere.
Is that on the left? Or
¿Es
the
en el
right?
lado izquierdo o derecho?
De la izquierda.
Left side.
And finally, clip 3.
Would you be surprised that much of the evidence that we collected during our investigation points to Victor as the person that hurt the student?
Va a quedar usted sorprendido si la evidencia que nosotros agarramos está indicando que Víctor lastimó a esta persona.
Tienen que tener evidencia, como que digo.
Eso no es que le pregunté. Va a estar sorprendido, sí o no.
Si usted dice
¿Sí o- va a estar sorprendido, sí o no.
yo no puedo decir que sí porque no sé, yo no puedo decir que sí.
Si yo voy a decir ahorita que su hermano Víctor
Ah,
le lastimó la persona que estamos investigando.
quedaré sorprendido, quedaré sorprendido, quedaré
Of course, I'm going to
sorprendido.
be surprised. Of course, I'm going to be
Claro,
surprised.
porque tiene que tener evidencia, me
So
imagino.
you're going to have to have evidence.
Yes, we understand.
Yeah.
Entendemos eso.
But again, he doesn't know, you don't know anything about that, correct?
Pero otra vez, usted no sabe nada de eso.
No sé nada de lo que está pasando ni nada, me quedo sorprendido porque me están investigando a mí también, me quedo
He
sorprendido.
says, I'm surprised that you're investigating me as well. I'm surprised.
So-
At no time in the past 12 to 24 hours did Victor tell you any information about hurting somebody.
Entonces, en ninguna vez, ahorita de las 12 a 24 horas, ha te dicho Víctor que algo olvidó, que pasó algo.
¿Qué pasó algo?
Sí.
No.
No.
At any point in time, did you participate in trying to cover up somebody being hurt?
En cualquier tiempo, participó usted en alguien estando lastimado.
No participaba en nada malo que no me involucre en nada, ¿entiendes?
Dígame otra vez.
Que no participaba en nada.
I didn't participate in anything.
And that completes the clips of that interview that distinguishes the fact finder to consider, and of course, the other side can play what they wish, and at this time, I'll pass it.
Good morning, Agent Fire.
Morning, ma'am.
You interviewed Stephanie Slayton for this case.
That's correct.
In your interview with Ms. Slayton, she was cooperative.
Yes, she was.
She volunteered to let you download her phone.
She volunteered to allow us to download her phone. We did not do it.
And she expressed fear of speaking to you.
Yes.
She specifically was afraid of retaliation for her statements.
Yes,
Retaliation from Diego.
that's correct.
When you confronted Diego about whether or not he had threatened Ms. Slayton, he denied doing it.
Correct.
When you were speaking to the state, you said that you had no evidence to contradict Diego being at home on the morning of February 22nd.
I had no evidence to contradict that he was anywhere other than at home. He did not appear on any video. In the apartment complex, he did not appear on the trailer camera.
Multiple people reviewed that video of someone throwing away a jacket in the dumpster.
Yes.
Multiple people identified that person as Diego.
The only person that I'm aware of that identified it as Diego was Stephanie Slayton.
Bethany Paisley also said
Objection, hearsay,
it's rebutting, it's impeaching
call a
him.
witness.
No, it's Bethany Paisley also said that the person in the dumpster video looked like Diego.
Looked like Diego, but to the best of my knowledge, she was not confident in that identification.
No further questions. Bethany Paisley couldn't tell you who it was in the video, is that right?
Correct.
And the people that could tell you were Roast Belly, correct?
Yes, ma'am.
Who came from New York with Jose Ibarra, right?
Correct.
And lived with Jose Ibarra for months.
Correct.
Is the same race as Jose Ibarra.
Correct.
Speaks the same language as Jose Ibarra.
Yes, ma'am.
She was able to identify him from the video.
She was.
Was she in any doubt in her mind that that was Jose Ibarra? Did she ever express doubt to you?
No, ma'am.
Same question about Diego Ibarra. Diego Ibarra is Jose's brother.
Yes, ma'am.
Diego Ibarra identified his brother in that video.
Yes, ma'am.
Did Diego Ibarra express any hesitation, any doubt that he was looking at his own brother?
No, ma'am. He said, of course I know my own brother.
And he did it in both videos, correct?
Yes, ma'am.
Stephanie Slayton, how long had she known Diego?
Maybe a little bit over 6 months.
Same question about Jose Ibarra. How long had she known him?
A similar period of time.
And she's the only person who expressed an opinion different than that of Jose Ibarra's brother, correct?
And I'm aware of, yes, ma'am.
And the only person that expressed an opinion different than that of Roast Belly, Jose Ibarra's roommate.
And I'm aware of, yes, ma'am.
And in your investigation, Special Agent Beyer, is Diego's DNA underneath Laken Riley's fingernails?
No, ma'am.
Is Diego's DNA on the blue jacket that was found in the dumpster?
Your
No,
Honor,
ma'am.
object. This is a closing argument. She's making this witness that she has the view.
Is Diego's thumbprint on Laken Riley's phone?
No, ma'am.
That's all I have, Your Honor.
Anything else, Ms. Beck?
No, Your Honor.
Can you excuse?
Yes, sir.
No objection.
Thank you, Judge.
Anything else from the state?
No, sir. The state rests for rebuttal.
Anything from the defense?
Can I just look at these last exhibits real quick?
While you're doing that, I'm going to review the exhibits, or is that what you want to look at?
Yeah, I just what they were, but I just want
Give me a moment to look at these exhibits.
Yes, sir.
announcement by the state and the defense, the evidence is closed.
Yes, Your Honor.
Are you all ready to go into summation?
Stays ready, Your Honor. That's ready, Your Honor.
Okay. Ms. Ross, you have opening and concluding.
Yes, sir. May it please the court and counsel. Your Honor, Laken Riley herself has given you all the evidence you need alone to find this man guilty of every single count in this indictment. And as I said in my opening, and what the evidence is shown in this case, is that she did fight. And it is a direct result of that fight that gives you all the physical evidence you need to convict him. And if you only had that physical evidence, you would have enough to convict him. But what you have heard in the last few days in this trial is video evidence laid on top of the physical evidence that corroborates it. Digital evidence laid on top of the physical evidence and the video evidence that all corroborate one another. And the three forms of that evidence in this case, the physical evidence, the video evidence, and the digital evidence, combined twist this very powerful knot that this defendant cannot get out of. There is no way out for him. The evidence in this case has been overwhelming. And the evidence in this case has spoken loud and clear that he is Laken Riley's killer, and that he killed her because she would not let him rape her. And look no further, you have to look no further to his actions 73 minutes before he encountered her on the trail to know what he was up to that day. And so not only does the physical evidence identify him, the video evidence identifies him. His own brother identifies him. His roommate, Rosebelly, identifies him. The people who he was living with condemn him. But his digital evidence of posting selfies of himself wearing what is basically his rapist gear an hour before he leaves his house, that condemns him. He has condemned himself. And what I'm going to do in the time that I have before this court is review the evidence that this court has heard and ask that you find him guilty on every single count of this indictment, not because you feel sorry for anyone, but because he earned it, because he deserves it, and because we have proven it beyond a reasonable doubt. Let's start with the physical evidence. The defendant's DNA is under the right fingernails of Laken Riley. And it is only Laken and this defendant in that sample, and no one else. It was first done at True Allele, and because R. Hennis and this defendant are blood brothers, he couldn't be excluded under YSTR. And then it was Diego who could be excluded by YSTR because he has a genetic mutation. But True Allele, when looked further in at the sample, eliminated both Diego and R. Hennis. So the evidence in this case has been, and is, that it is only the defendant and Laken Riley underneath her right nails. And how did that happen? Because she, in her fight, marked him, scratched him. And the testimony from Ms. Hinkle yesterday, when asked, well, how do you get a person's DNA underneath your fingernails? One of the first things she says is scratches or bodily fluid. Casual contact is not enough, and wearing an item is not enough. And how do we know that? The black Adidas hat that we all see for our own eyes on Diego's head doesn't have his DNA on it. I mean, contact DNA isn't the magic bullet that everybody likes to pretend it is in front of a jury. But we know Diego was wearing that hat. You can see it for your own eyes. And I'm gonna talk a lot more about that hat and why and how Diego was wearing that hat a little later. It is the defendant's thumbprint on Laken's phone. And this was from the Daubert hearing. This is, first of all, the digital image of Special Agent Daniela Stewart, and that is digital image 597, which is in evidence on one of the thumb drives. And the court heard the testimony that we adopted from the Daubert hearing, and I have here states 28 from the Daubert hearing of October 11th, where Sergeant Stewart of the ACC Police Department, who has been a latent print examiner since 1994, has looked at thousands of prints, compared that image that Special Agent Stewart took on the night of Laken Riley's murder when they finally found her phone after dark away from her body. And he compared it to the known fingerprints of Jose Ibarra, and he did it twice. And he found and explained to the court at the Daubert hearing, which we have adopted as part of this transcript, 15 points of comparison and similarities between the latent print left on Laken Riley's phone and Jose Ibarra's fingerprints. So in order to find this defendant not guilty of killing Laken Riley, you would have to disbelieve DNA. You would have to disbelieve fingerprint evidence. And even if you did that, you would still have this. Quite frankly, she got him. She scratched him. And you heard the testimony from Sergeant Epps and from Corporal Sayan. The left wrist was still oozing. Both of them saw that. And when asked, what's with these injuries by Corporal Sayan, and we played that part of the body cam video for the court to see, Corporal Sayan wasn't coming at him hot. It was super calm and casual. They're out there laughing. They're laughing in those videos. Smoking, talking on their phones, talking to one another, all four of those people inside that residence, chillaxing. And Sayan's like, my friend, do me a favor, show me your hands. My friend, how did you get those injuries? And his first response is that of a monstrously guilty individual. What scratches? Y'all don't see these scratches. We don't see these scratches. So in order to find him not guilty, you would have to disbelieve your own eyes. What scratches, he says? All of those scratches. And there were more scratches than that, because when Daniela Stewart, and those photos are in evidence to you, when she photographed him and made him take his shirt off, there are scratches on his back. His back. And you know what that's consistent with? That is consistent with him asphyxiating her, being on top of her, compressing her chest, and smashing her head in with that rock. That's what that's consistent with. How do you get scratches on the back of your neck? How do you get scratches on your back? Laken left those scratches, and the physical evidence says that she left those scratches because that is why his DNA is underneath her right fingernails. She marked him. She marked him for everyone to see. She marked him for you to see. And the digital evidence that she wore that day also corroborates everything, all the physical evidence and the video evidence. We will never know what he did to her on that trail and in what order. And we'll never know what he did to make her stop. Because quite frankly, I'm certain she could outrun him if she wanted to. But she didn't. And he did something to her where she knew immediately she was in trouble. And how do we know that? From the Garmin and her phone. Simultaneously, if you put those two things together, which is what this graph is that you saw and that's in evidence, at 9:10 a.m., and there's some seconds in between them that really only matter if you're an Olympian swimmer or a track runner. It's so close together in time, it doesn't matter. It is simultaneous. Simultaneously, she enacts or tries to call 911 from her phone using the SOS function of her iPhone. And we know that from her phone. And simultaneously, at that same time, she comes to a dead stop. She stops in her tracks. And we know that that is the time she meets him on the trail. And how do we know that? Well, we know that from the FBI. Because there is a chart that I'll show you a little later in my closing argument, where at 9:10 a.m., their digital profiles overlap one another. They have met in that woods. His from his timing advanced data from his phone. And remember, the moment he enters the forest, his Wi-Fi is no longer active. And so there's no Rubin data from about 8:55 to about 9:40 a.m. And that is evidence of his guilt too. The fact that he's in that forest, that means he's in the forest. And we know he's in the forest because he has no Rubin data. And we know he's in the forest because his timing advanced data puts him there. And they meet simultaneously, digitally, on that trail at about 9:10 a.m. And so something happened. And this is her Garmin watch. And we know there was a fight because the way that it looks, look at this, on the trail, she's still on the trail till about 9:14 a.m. And then her Garmin starts moving off the trail. And he takes her off that trail 65 feet, 64 feet and 11 inches to be exact, 65, close enough. And he does that for only one purpose, and that is to isolate her so that he can victimize her. And that is exactly what he did. But the true allele under her nails, as damning as it is, isn't all that you have. And you could put that aside and the fingerprint aside, although there's no reason to. On the jacket that he is seen throwing away about 12 minutes or 14 minutes after her heart stops beating. And it is no coincidence that he is in that forest until her heart stops beating at 9:28 a.m. And it isn't until around 9:40 that he emerges. He is with her that entire time. But about 14 minutes afterwards, he is seen on video dumping a jacket that you have here in evidence that you've seen a lot, so I'm not going to show it to you again, that has a mixture, and this is traditional DNA. This is not true allele. This is not probabilistic genotyping. This is traditional DNA, and it is a mixture between only two people, Laken Riley and this defendant. And it's no mistake that it is blood, a mixture of their blood on that jacket. And on that jacket also are 29 hairs that are consistent with Laken Riley that all have been not all of them, but several of them have been forcibly removed from her head. And they were wrapped around the button that you see in some of the photographs when Officer Davis testified, the way that he saw it. And it is a rare day that as a prosecutor, we ever get such great evidence of tampering with evidence, but the defendant himself is on video, and here it is. And now I guess the defense will have you believe he just threw away that jacket right at this moment just because he just didn't want it anymore. That's not reasonable. He threw away that jacket because he knew exactly what was on it. He knew it was his blood, he knew it was her blood, and he knew he had to get rid of it. And he also knew that he had to get rid of his gloves, and so what he does further on in this frame is you can see him take them out of his pocket and throw it in the bushes. And on those gloves is Laken Riley's blood. He threw away the gloves because he knew what he had done. He knew her DNA or her blood would be on that, and he got rid of it. That is what we call consciousness of guilt in our business. He threw away those items because he knew he had killed her, and he threw them away because he didn't want anyone to find him. That's why he did it. And what's so fascinating about this video is the part where he looks at the hat. Let's talk about that. That's what he didn't throw away, the hat. It's his brother's hat. Diego said it in the interview. That's my hat. He wears his own brother's hat to go kill someone, and he looks at it. Oh, no blood on that. He didn't see any blood on it, although there is some blood on it. Puts it back on his head, doesn't throw that away, and then lets his own brother walk around with it the next day. And the fact is, if Diego had not been wearing that hat, we may have never caught these people. We may have never caught him. But Diego was wearing that hat. You think for 1 minute, Diego would have to be the dumbest killer on the face of the planet if he killed Laken Riley and was still wearing that hat around. Because what Laken Riley's killer did was he got rid of all the evidence. At least he thought he did. And that hat right there, he couldn't see her blood. And he gives it back to his brother. And luckily for all of us, his brother decides to wear that hat that next day. And we know his brother wasn't wearing the hat on that day because you got to see the video for yourself where Diego goes to work on the day of Laken Riley's killing. He's at work and he's wearing a completely different hat. And each day that we have of the videos of where he's going to work, he's wearing a completely different hat. So this defendant, this killer, gives a hat back to his own brother that he was wearing when he killed Laken Riley. And I have to take a moment. You know, the officers in this case have done a lot of things. They dived into dumpsters. Daniela Stewart told you she was on her hands and knees on that crime scene looking for rocks that were somewhere. Couldn't find any rocks around where Laken Riley was murdered. A lot of it, you know, Sergeant Timothy Johnson, whose testimony we adopted from the hearing in October, you know, just hitting the streets looking for things. Zach Davis, dumpster diving. It was a combination of good police work and, quite frankly, just luck. We were lucky that Diego decided to wear that hat. And do you think for 1 minute if Diego had killed her, he would have put that hat on? No. And looking in the video that you see, and you saw slowed down versions of it, Diego has tattoos on the back of his neck. They are not in that video. Rosebelly herself, who knows both of these two, identified this defendant in that video. And if you're concerned about whether she's right about that, well, the FBI's digital profile of this defendant's device hovers over that dumpster at 9:40 a.m. It's him, and there is no doubt that it's him. Here is the FBI profile, digital profile from the CAS team of the defendant's device now over the dumpster. In the center of this is D1, 9:40 a.m. He's at the dumpster that we just saw him at, dumping bloody clothes. And how do we also know he's back at his apartment at that time? Because Special Agent Hipkiss, who extracted 1B7, said at 9:58 a.m. the device is plugged back in and charging, which means he's back home. But he's not done. And before I go on to the other videos, these are all the selfies of this defendant on his phone 1B7. And I understand, and I suspect maybe the defense will argue, well, Judge, you know, other people used his phone. Yeah, they did in October. And then the other 2 months that they want to talk about are other 2 accounts. Oh yes, Diego has a Google account that has been accessed from 1B7. Both of those accounts that they talked about, one a Facebook, one a Google, I can't remember exactly, but there were 2 of them. Rosebelly had one and Diego had one. One of the accounts was closed in January, and the other one, Rosebelly, was closed in February of February 12th of that year. So on the day in question, on February 22nd of 2024, there is zero evidence, no evidence that anyone other than this defendant was using that phone. And any attempt to argue that someone else was is just pure speculation. Because the only activity on the phone prior to leaving is him taking that selfie at 5:30 in the morning. That's it. There's no one texting, no one WhatsApping, no one calling in the time that he's out hunting and killing. Because he's holding the phone, and he's a little busy, because he's looking for victims. He's looking for females. Nobody else is using that phone. And the FBI said, and the phone tracks his own video. You could put the video of him at the bus stop, which I'll show, and put it with the digital profile of the phone, and they track one another. So the videos and the digital profiles track one another because he's holding the phone at the time. And this is what he does when he gets back. His phone is plugged in at 9:58 a.m., but he's not done destroying evidence. That shirt that he's seen wearing with the black and white pattern in the video, in the dumpster video, a few minutes later when he comes out of his house at 10:21, he's changed. And now he's wearing the clothes that he's actually arrested in. This is him, 10:21 a.m., and he's got a bag in his hand. I really wonder what's in that bag. Never found that bag. And he didn't want anyone to find that bag. And how do we know that? Because he's walking towards a dumpster. And Sergeant Norris said that that dumpster in that part of the apartment complex had been picked up about 45 minutes later that day. So they weren't able to get and see what was in that bag. And no one ever found what was in that bag. But you know what was also never found? The striped bag that he's wearing over his, that sling bag that he's wearing in both the dumpster video and in the bus stop video. That bag was never found, ever. And I suspect it's because it was in that bag that we just see. And here he is coming back 3 minutes later, and there is nothing in his hand. He's gotten rid of the rest of the evidence, because that's what guilty people do. So the digital evidence that I have talked about, in summary, from Special Agent Jay Burney of the CAS team, it is his opinion that he left that house at 6:52 a.m. and that he returned around 9:50 a.m. And that there is no Reuben data on that phone from 8:55 to 9:40, which is consistent with him being in the forest. This is the slide from, and this is what summarized Special Agent Burney's testimony, that at the time at 9:10 a.m., so on this slide here that was before the court, page 29 of his exhibit, at 9:09 a.m. to 9:12 a.m. is where on the trail Laken Riley and this defendant meet, digitally and in person. And so that is pretty much the evidence. His DNA is there, his thumbprint is there, and he's on video dumping evidence associated with the crime shortly thereafter. I want to talk to you about the charges in the case, and this is usually when I would go on much longer with a jury, but I don't think there's a need to do that with this court. These are slides that I use in murder cases where I close all the time in front of juries. The court is aware that in the state of Georgia, we have malice murder. The defendant is charged in count 1 of this indictment with malice murder. Malice can be proven in 2 ways, as you know, but we really don't even need to talk about implied malice in this case. This is express malice. Everything this defendant did to Laken Riley on that trail showed his intent to murder her. And what express malice is simply the intent to kill. And so what evidence is there that when he interacted with her on that trail and when he drug her off that trail that he intended to kill her? Well, look no further than the evidence of the medical examiner in this case. He put huge holes in her head with a rock, and he did it more than once. And there could be no other reason to do that other than to silence her forever, so that she could not call Sergeant Maxwell or anyone from the University of Georgia Police Department and report that he tried to rape her. Because guess who did call the police on him? Teacher Sweet. And we're going to talk about that count in the indictment. And he ran away after she confronted him at the door. So he had a motive to kill Laken Riley, but you don't even have to go that far. All you have to do is look at his actions and look at the state's exhibits that we admitted through the medical examiner and look at those 9 holes in the left side of Laken Riley's head. That's intent to kill. And the rock sure is a deadly weapon, especially when used that way. He used a rock like it was a hammer. And that's what he did to her. That's intent to kill. The petechia, also, because these are concurrent causes of death. Asphyxia. He asphyxiated her in some manner. Again, we'll never know everything he did, how he did it. But he asphyxiated her, we know enough. That caused petechia in both of her eyes and even at her lips. That is a tremendous amount of petechia that she has there from a compression or a strangulation injury. He was depriving her body of oxygen long enough to form those wounds on her. He intended to kill her. There is no other reasonable explanation for that conduct. We have also charged 3 counts of felony murder in this indictment. I'm not even going to define it for the court because I know you know what it means, so I'm just going to go straight to the felonies. And they are kidnapping with bodily injury, aggravated assault with intent to rape, and aggravated battery. First, with the kidnapping with bodily injury. That is exactly what happened in this case. And that actual felony precedes the murder in time, because he didn't murder her on the trail. He took her 64 feet and 11 inches off the trail for the purpose of victimizing her. That is asportation, that is recognized under our law. And it is what permitted him to do the things to her that he wanted to do all along. And if he hadn't had aspartated her off that trail, he would have been interrupted. So it is a kidnapping with bodily injury. And I have a crime scene photo here from, again, Daniela Stewart, where she shows marker 1, which is Laken Riley's other AirPod. And that's how we also know there was a struggle on the trail. Sophia and Lily find, and we know Laken was listening to music when she was running. They find her AirPod, one of them, in the middle of the trail. And there's a photograph in there. A little towards the side, but still on the trail. AirPod number 2 is found by Daniela Stewart, where marker 1 is off the trail. So there was some kind of struggle between the two of them on that trail, and it's also shown on her Garmin, where she loses her AirPods on the trail. And he takes her off that trail. And we'll never know exactly how he took her off the trail. Did he pick her up and carry her? Did he somewhat drag her off the trail? Did he somewhat push her off the trail? We know that he took her 65 feet because we know that's where her body was found. And also Daniela Stewart saw like a leaf. She called it a displacement of the leaves, and she marked it with those orange flags, but no real dragging marks. So that's a kidnapping with bodily injury. Taking her off that trail, and in the commission of that crime, he kills her. He is guilty of felony murder, with the underlying felony being kidnapping with bodily injury. It's not contested that she has bodily injury. But the aggravated assault with intent to rape, there were a lot of questions about, well, could her shirt be up from dragging her? I suppose the defense might be, well, I killed her, but I didn't intend to rape her. Well, that makes no sense. Because the only thing that makes sense about why these two individuals that don't know each other, never met each other, had this encounter on this trail at this moment while Laken is out for her morning jog, is because he wanted to sexually assault her. What evidence do we have of that? What has been left behind from this struggle that we can discern that? What's circumstantial evidence? Well, her clothes are in 2 different directions. And it is important to talk about her clothes. And we're not talking about her clothes in order to shame her as a female. No. It's evidence on how she wears her clothes. She would wear running tights when she ran because that's what's comfortable. And that's how you run. And she would wear them over her navel because when you're running, you want your clothes to stay put. And she wore a Lululemon jacket, and she wore 3 layers of clothes that day. And it's important to talk about that from an evidentiary perspective because these are tight running clothes that are designed not to move. Not to move. And if they want to say dragging may have caused one of the layers of clothes to come up, all right, I'll give you 1. But I can't give you 3, and I can't give you the clothes going in 2 different directions. Her shirt was up. Her running bra up. Her jacket up, and her breasts were exposed in a way that you saw in Sergeant Maxwell's body cam video, and in a way that Special Agent Beyer testified to the court. He photographed them. They were twisted all together in a knot almost above, and like almost tying down or pinning down her shoulders. That is not an accident, and that is not from dragging. And if you even want to think that that was from dragging, then how do you explain how her tights are down below her navel? She never wore them that way. Her underwear is pulled up, and you can see it in the body cam video, and you can see it in the photos from Special Agent Beyer, and her underwear has been torn. He did that to her. He did that to her after he drug her off the trail. And he did that to her because he wanted to try to rape her. And we don't have to prove a completed rape, and thankfully she wasn't raped. But he tried to do it, and he was unable to complete it for some reason that we will never know. Maybe he didn't like the fight. Maybe somebody ran by. Who knows? But he didn't complete it, and we don't have to prove that he completed it. Injury to Laken's pubic bone, State's Exhibit 316, that also corroborates that he attempted to rape her. Why is that injury so low? All these injuries to her stomach, these linear injuries, that means her shirt was up when he's on top of her. Could it have been the bag? Possibly. It's consistent with the metal object. Never found the bag, don't know. But there's no reason for her to be exposed that way unless he was trying to sexually assault her. That is the evidence of aggravated assault with intent to rape. It's the only thing that makes sense about the encounter, but there's all that physical evidence that supports and corroborates that that's exactly what he did out there. Aggravated battery. I could talk forever about aggravated battery and disfiguring her skull. Just look at State's Exhibits 305 and 307. I really don't need to say anything else. Look at those 2 exhibits. That is the very definition of aggravated battery under Georgia law. He is guilty of aggravated battery and felony murder, with the underlying felony being aggravated battery. Obstruction of a 911 call. The SOS call was made, no doubt about that. We got that from not only Laken's phone, but we also got that from Kevin McCreevy from the 911 call center. She made a call. She made a call, it was answered. You heard the call. Kevin McCreevy testified. The caller hung up on the 911 center. That was his testimony. The 911 center called Laken back twice, and that you could see that in her phone. And neither call was answered. Who hung up the phone? Well, he did. How do we know that? State's Exhibit 28. It is no coincidence that his thumbprint is on her phone where you would go to hang up an iPhone. And also on that call, that is about a minute call, you hear him say, yo, Tango. I have. Yeah, you do. You do have. You had her phone. And he hung it up. And when 911 called back twice, no one answered. And her phone is separated from her body. So her body is in, she was murdered by the tree. She was moved and hidden and put leaves over her. And it worked because it took Sergeant Maxwell 20 minutes to find her, and he had her digital profile. And we didn't play the whole thing, but he testified it took him 20 minutes. And because he hid her, because he didn't want anyone to find her. We were lucky there too. But he separated her from her phone. Her phone was so far away from her, it took them hours to find it. You heard Sergeant Norris, I was walking through shining a flashlight. I almost stepped on it. You saw the video of his body cam. You saw how dark it was out there when they found his phone, her phone. He separated her from her phone because he didn't want her to complete that 911 call. And she didn't. He's guilty of that. Tampering with evidence. I've already covered this. It is rare we get this on video, but we got it on video. He's throwing away the bloody jacket. He's throwing away the bloody gloves. That's how it is alleged in the indictment. He's guilty of that. And I've already covered this. There he is. No tattoos, been identified, looking at the hat that he decides to keep. Here he is on social media, if you have any doubt that that's him, wearing the hoodie and the black Adidas hat. Did you a huge favor there as the fact finder. It's 5:37 a.m. on the day of the murder. He's about to go out, and that's how he's dressed. He is alone in all of these times. Trail cam video, Tejaswi, and Sally, the other female runner that encountered him at 8:24 a.m., where he is what? In the woods. And how do we know that? Because when Tejaswi calls the police on him at about 8 o'clock in the morning, he vanishes and disappears into the back, and Sergeant Rabu testified in the direction of the IM fields. And he stays there. What's he doing there? What's he doing there? Well, he isn't running. I doubt he's bird watching. He's sitting there waiting for someone to come by, because his first intended target, he wasn't able to get. And I'm gonna ask if there are any cameras up. I wanna show a portion of something, and I don't want the peeping victim to be seen, the Tejaswi.
So I will direct media to not publish this as well as.
All right, so are we good? We're good. Okay, I'll let you know when it can come back up.
Hey, I'm sorry. Hey, can I come in or you already? So I'm just gonna get one thing over the radio. 6427, I believe it's gonna be the north facing at the end of the building. Hey, so are you okay? Oh, gotcha. I understand maybe a little bit scary. I'm just gonna be asking a couple questions, get some clarifying information, okay? So you're taking a shower, correct? And you heard something going on?
Yeah, I heard like something was moving, and I just heard someone from upstairs. I usually hear that. And then when I actually came out, I heard it coming from the door.
Or you heard it coming from this door?
Yes.
Okay.
So I went to see to the people, and then I saw actually someone was crouched down and then trying to I think I just open it.
Okay.
And then I thought it was just maintenance. I thought of opening, but then I was like, why would they do that? Very good personal.
Yeah.
So, and then I said, excuse me, and as I said that, they tried to duck out, but I could see them ducking.
Mm-hmm.
And then they went away, and then after that, I tried to get the phone. Then when I was standing by the door, then I could see them peeping, trying to peep and take a look.
Yeah, they're trying to look into that. So at no point did they ever enter your
No, they didn't.
okay, good.
In this frame, you can see, as some people would say, clear as a country mile to the back of Building S from Tejaswi's apartment. She absolutely saw him looking in her apartment. And when she said he was ducking, you can see that for yourself in the trail cam video. And the peeping Tom, and I'm gonna, okay, y'all can come back up now. Are we good? Okay. Is important as a charge, and you can see how scared she was and frightened in that video. She was unnerved about what happened to her. She's in the shower, and that's when he decides to try to open her door. Again, he had been outside her apartment for an hour. The testimony from Sergeant Rabu, and you saw this video yesterday, from GBI Cyber, he first appears on the trail at 6:52 a.m. according to that trail cam video. Guess what that coincides with? His digital profile from the FBI. His phone is moving at the exact same time that you see him on this video for the first time. And what this does is, it is a crime, and he is guilty of that crime, but it shows his state of mind. You watched the video yesterday. He's there for an hour. You see students kind of mulling around, some of them waiting for the bus, a lot of them on their phones. He is not pressed. He doesn't care. He talks to no one, he interacts with no one, and he keeps circling back and forth from Tejaswi's door to the back of her apartment, Tejaswi's door to the back of her apartment. And he does it 6 times. And he tries to open her door at least twice that we can see. And when she says he is ducking, there's her window, you've seen that image as well. Here is the part of the video at 7:54 a.m. You see him ducking. She is absolutely correct. And what's he wearing? He's wearing the hoodie, a black hat, black gloves, and carrying a cup. His digital profile puts him right over her apartment at these pertinent times. His Reuben data is collecting at this point because he's not in the forest. And so it's him because of that as well. His digital profile puts him there. He's wearing the same clothes. But if you have any residual doubt that that's him in the video, boom. His DNA is on the cup. The white cup that you can see him carrying in that video was found smack in between Tejaswi's apartment and Laken Riley's body, and it is his DNA on that straw. And yes, it's a mixture. It's not Diego's, it's not Artemis's, it's not anyone related to him. It's him and some other male, and there's alcohol in that cup. He's drinking alcohol at 7 o'clock in the morning while he's out prowling and hunting females. It's him. No doubt that it's him. And I want to talk about the gloves, because the gloves that he chose to wear that day, you heard from Alexander Coven of the crime lab. Luckily again for us, they were cheap. They're not latex. They're some kind of polyethylene, like plastic gloves that tear easily, is what he said. That was his scientific testimony. And those gloves were torn. And you saw photographs of them where Katrina photographed them at the crime lab. And because those gloves were torn, he was able, and maybe they were not torn when he was holding the cup, maybe they got torn when he's holding these rocks and murdering Laken Riley when she is fighting him. But at some point they were torn, and we know that because after they're recovered in the bushes, they go to the crime lab and they are photographed and they are examined. And the first person who sees them at the crime lab is Valencia Johnson, and she says they were damaged. The second person who sees them is Katrina, and she photographs them. And you have the photographs and evidence to use, so you can see for yourself that they were damaged. So what in the world is he doing outside a co-ed's apartment, wearing plastic kitchen gloves, a hoodie, covering up his face, and skulking around? He is trying to get her. And when he couldn't get her, he ran away into the forest, and he stayed there until he encountered Laken Riley about 73 minutes later. And then he did all of the things that we've already covered in the indictment. And I want to talk to you a little bit about circumstantial evidence, but not in a way that I would talk to a jury about it. There is no legal difference between circumstantial evidence and direct evidence. It's not bad, it's just different. And in this case, it is powerful. And it is layered upon layer upon layer. And there is no way out for him. He is guilty of everything in the indictment. I want to talk to you about the defense case. And this is actually something that a scientist said yesterday. It's amazing how trials are, how people say things and you never expect it. And they just have a life of their own. Trials. Ashley Hinkle yesterday, I think it was on Cross. The absence of evidence is not evidence of absence. I couldn't say it better myself. I suppose their defense is Diego did it, because that's all we've been talking about is Diego. And yeah, Diego was a suspect because he's wearing the hat that they saw. But eventually, you know what the officers didn't do in this case? They did not turn a blind eye. They got Diego's phone, they got Diego's DNA, they interviewed Diego, and they followed it to its natural end. They looked through hundreds of hours of video. You saw the chart that Detective Norris put in on Friday of all the videos around the IM fields. And there were multiple cameras. He and Sergeant Rabu and Special Agent Lucas Beyer, they watched hundreds and hundreds of hours of videos. Guess who's not anywhere near the IM fields at the time and on this day? Diego. He is nowhere to be found. And the only way that Diego could have done this crime, and the only way that it could be even like a reasonable hypothesis that he could have done this crime, is if he had two things. Number one, magic pixie dust. He would need the magic pixie dust to put his brother's thumbprint on her phone. He would need the magic pixie dust to put his brother's DNA underneath Laken Riley's fingernails. And he would also, in addition to that, because of the video evidence, he would need one other thing. And that would be Harry Potter's invisible cloak. He would have to put that on and go to the IM fields and do these things because nobody sees him. And I want to talk about Stephanie, because what your decision is today is it's Stephanie versus science. Stephanie who wants to invoke the fifth when asked about whether she had a sexual relationship with Diego, which goes to her motive for being here. And the conversation, which is so interesting, she said she had with Diego on the night of the 22nd, after the police were in her apartment, and we know it had to be the night of the 22nd because it was after Laken Riley's body was found, which was noon on the 22nd. But before 8 a.m. in the morning, when Sergeant Johnson sees Diego wearing that hat that his brother left in the apartment after killing her, and she says between that time she had a conversation with him at some point. Well, guess where Diego was that day on the 22nd? You saw it for yourself. He was at work. And he was at work till about 11 p.m. And it was Stephanie's birthday, and she was out drinking. And she drinks so much, Judge, that she even said, and the GBI Annie Mormon confirmed, she was drunk when she was talking to the GBI the next day still. And maybe she did have some semi kind of conversation with him. And even then, if you take her at her word, it's not a confession. There is no evidence that he did anything except be a brother to him. And it's pretty low down that you're going to take the killing hat and then let your brother wear it around in the apartment complex the next day. But that's just what a killer would do. So to believe her, you would have to disbelieve all of that. And then today we heard some unreliable inmate hearsay. Not reliable. And cannot weigh anything against the mountain of forensic evidence, video evidence, and digital evidence that you've heard in this case. And yes, here is Diego wearing that hat. You think he'd have worn that if he had known what was on it? He didn't know. Glad he wore it. He didn't know. And so that completes my portion of this closing argument, and I will cede to defense and see Your Honor at rebuttal. Thank you.
Ms. Beck. Pause.
Your Honor, Ms. Ross, evidence that is subject to more than one interpretation is not proof beyond a reasonable doubt. As Mr. Kirby said in his opening, the evidence in this case is graphic and disturbing, and it is deeply sad. And I don't envy your position, Your Honor. The rest of the people in this courtroom get to be human. We can feel shock and outrage. But Your Honor is the court. You are the embodiment of law. And as the court and the fact finder, the law requires that you not allow your verdict to be swayed by sympathy for anyone. It must be based on the evidence. Mr. Ibarra, acting on our advice, elected to have a bench trial, trusting that Your Honor could, and believing that Your Honor would, set aside the emotions in this case and simply consider the evidence. So I'm going to catalog for Your Honor why I think the facts and the evidence in this case should leave me with some reasonable doubt. Before I do, I want to touch on two legal principles. Your Honor is already familiar with them, but I do want to make my legal arguments clear for the record. The first legal principle is embodied in OCGA 2446. And that law requires that when the state's case is built on circumstantial evidence, they have a higher burden. They have to go one step beyond proving their case beyond a reasonable doubt. They also have to exclude, beyond a reasonable doubt, any other theory consistent with Mr. Ibarra's evidence, in a sense. Because the evidence is subject to more than one interpretation, it is not proof beyond a reasonable doubt. And while the evidence in this case is voluminous, it is circumstantial. The second principle is the difference between a party to a crime and accessory after the fact. This principle is codified in OCGA 16-1050, and I would also direct Your Honor's attention to Purvis versus the state. Purvis is spelled P-U-R-V-I-S. That is 208 Georgia Act 653. And that case basically explores the difference between proving that someone is involved in a crime while it is committed versus proving that someone is involved in the cover-up of a crime. The important difference, Your Honor, is that if the evidence shows that Mr. Ibarra was involved in the cover-up of the crime, but does not prove beyond a reasonable doubt that he was involved in the murder itself, Your Honor would be authorized to find him guilty on the tampering with the evidence charge, but not with the murder. So now I want to talk about the evidence that was presented. First, I'm going to discuss the reasonable doubt in the state's case that Mr. Ibarra was involved at all. Then, I'm going to discuss two alternative theories that are consistent with the evidence that would show Mr. Ibarra is not guilty of the malice murder or the felony murders. And then finally, I want to discuss a few specific elements of a few crimes and the evidence we've heard on those. The state bases its case in chief on some categories of evidence. There's DNA, there's a fingerprint. It talked about the digital evidence and the surveillance footage. There is reasonable doubt in each of those pieces of evidence. I'll start with the DNA. There is doubt based on what was tested and doubt based on what was not tested. When Ashley Hinkle was on the stand testifying and Mr. Kirby was cross-examining her, she talked about the limits of her science. She talked about the fact that some of the factors involved in testing for DNA are controlled by humans and some are run through a program. She decides how many people's DNA is on an object and then asks True Allele software to compute from that number of people the likelihood of whose DNA that is. Her decision impacts how the test is run. She told you that there is an element of randomness in True Allele and that if they run the same test multiple times, different probabilities will come out. And that's what happened in this case. Your Honor should be skeptical of the DNA evidence also because of something that Ms. Ross talked about. A hat that we know for certain was on Diego. A hat that we know for certain was his hat that he claimed. Nothing on that hat tested positive for his DNA, which goes to show that even if someone is wearing clothes, touching clothes, owning clothes, DNA is not always going to show up when the lab tests it. People in court wore gloves when they handled this evidence because they were afraid of cross-contamination. They were afraid that their touch would impact the reliability of future DNA tests. When you look at the apartment from which these clothes were taken, that is a lab tech's nightmare. There are clothes everywhere piled together. It's 5 people living in one room. And the state's theory is that they shared clothes. Of course their DNA is going to be on each other's clothes. It's more than possible that one brother's DNA would get on another brother's clothes. In fact, it's probable. And who would have had the most cross-contamination? Diego and Jose, because they shared a bed and they shared clothes. When it comes to true allele, I do believe our argument is hampered by not having experts, but there are clearly flaws with that testing system. One of the tests that they ran for the evidence in this case came back to a retired GBA agent who was not involved with the testing of the case and was not in any way could have had their DNA on that object. There's also doubt based on what was not tested for DNA. There was a bloody thumbprint on Laken Riley's phone that they believe was placed there by the killer. And they chose, rather than swabbing that for DNA, they chose the less reliable scientific method of fingerprint evidence. There were no swabs tested of the phone, even though Saunders testified that they did take swabs. There were no swabs tested from Laken's neck and torso. But perhaps the most important is that they swabbed Jose Ibarra's hands and his fingernails. And their theory is that his gloves ripped enough for him to leave a fingerprint on a phone. That rip would have allowed him also to have contact with Laken Riley's body. And then, if they had tested the swabs on his fingerprints, we could have seen if Laken Riley's DNA showed up on his hands. But they did not. They don't get to cite a name of a guy we don't know, James Sebastian, and call it a day. They should have provided some reason why they didn't test these swabs, and they gave Your Honor none. They also didn't test any of the gloves found in Diego's bag. They had a visual examination, but we know from the state's own evidence that that's not enough. Katrina Ostapovich testified that she has to use a special light to see blood on objects. She called that light an ALS and compared it to a black light, because blood is not always visible to the naked human eye. So Saunders' visual examination of the gloves in Diego's bags should not persuade Your Honor beyond a reasonable doubt that they did not have blood on them. The fingerprint evidence in this case is also questionable. At the Daubert hearing, Tim Stewart testified about the APHIS database, and that is a federal database that stores any fingerprints deemed valid enough for comparison taken by federal agents. There are hundreds of thousands of people in that database. And Tim Stewart, before he did his own comparison, ran the latent fingerprint from the phone through that database. And there was no match to Jose Ibarra. He wasn't even in the 120 possible candidates that APHIS populated for Tim Stewart. I want to also speak briefly about confirmation bias. When we were speaking to the medical examiner, she talked about how when she looks at the case, there's information already populated in the system that she didn't generate. The case number and the involved parties. And the involved parties in this case are telegraphed to the scientists at GBI as to how the state wants the evidence to come out. The information said subject Jose Ibarra and elimination Diego and Argenis Ibarra. And unfortunately, when you're testing for DNA and you know ahead of time the result you're supposed to get, that colors the process and weakens the scientific reliability of those DNA tests. Now, as to the phone location data, their theory is that Jose had the phone. Agent Hipkiss testified that Jose is the user of the phone. Their evidence relies on the fact that Jose had exclusive access to that phone, but that is dispositively not true. Norris testified that other individuals were communicating with other members of someone using that phone in October. The stipulation of the parties showed that there were other accounts on that phone. There were 2 Gmails belonging to Diego, and there was some evidence that that email account was active in January of 2024, which is a month prior to this. Rose Bailey had a Facebook Messenger account on there. Jose's mother-in-law had a Gmail account on there. There are multiple Instagram accounts belonging to Diego on there. That's all stipulated. And even if you consider that Jose had the phone, the testimony of Jay Burney shows that there is some shakiness as to exactly where that phone was at the time of the murder. The broad band of where that phone could have been due to the delayed timing evidence of the phone is quite wide. It covers parts of the Oconee Forest and parts that are outside the forest. He concluded that the user of the phone must have been in the forest because of the lack of Wi-Fi Rubin data, but he also conceded that that Wi-Fi Rubin data could have been lacking if someone turned off their Wi-Fi. That uncertainty as to what caused the Wi-Fi to not respond is reasonable doubt. In the dumpster video, Your Honor should have some doubt based on the angle and the quality of the video. Rose Bailey did identify Jose, but she testified that the reason she identified him was because of the hat and the shoes. The hat that we know Diego owns, and black slides that we know Diego owns too, because the agents found a second pair of black slides in the apartment when they searched it. So the hat and the shoes that Rose Bailey identified for Jose could just have easily been Diego's. In the 911 call, no one identified the voice. I don't know why the state didn't ask Rose Bailey, but she was here. Maybe she could testify to who's speaking, but no one did. And the phrase that the state would like you to believe is being spoken, yo tango, was heard by somebody who does not speak Spanish. We don't know what is being said on that call. We don't know who says it. There is an alternative theory in this case that makes sense of some of the discrepancies in the state's case. Jose was short, he was chubby, he was, according to the state, wearing slides the morning of February 22nd. I agree with the state that Laken Riley was physically fit, she was fast, she could have outrun him. But there's another suspect in this case who was taller, who was more physically fit, who was wearing sneakers on the day of the murder, and that is Diego Ibarra. We know from the dumpster video that the person throwing away the jacket is tall, because Officer Zach Davis testified the slot into which the jacket was thrown was about 6 feet high. The person in the video didn't have any trouble, it was parallel to their head or just above it reaching that slot. That suggests someone that's taller than Jose Ibarra. We also know from Joseph Clementi that there was a second person out wearing dark clothing, not a runner, on the day of the murder. He testified that between 9:46 and 9:48, he saw somebody who was skinny, wearing dark clothing, wandering around the intramural fields, and was about 6'9" or taller. That description matches Diego to a T. And we know it can't be the same person in the dumpster video because it happens at the same time. The dumpster video is at 9:44. Clementi is pretty certain about his timeline because he's tracking his position using a running app on his phone. Other evidence that suggests Diego is the one who killed Laken Riley is, of course, that the fact he was wearing a hat with Laken Riley's blood on February 23rd. According to the state, you can see blood on black clothes, so Diego, when he's choosing hats that morning, should have been able to see that the hat was bloody. But more importantly, Officer Epps testified that he observed dirt on the brim of the hat. Tim Johnson testified that he observed dirt on the brim of the hat. There is no way Diego put on that hat without noticing something was strange about it. And the reason he put it on, without questioning why it's got dirt and blood all over it, is because he already knew that it was there. The state would like to say that Diego would have to be the dumbest killer in the world to put it on, but unfortunately for the state, that's exactly what the person in the dumpster video does. After he examines the hat, he puts it back on. So if their theory is that's Jose, or that's Diego, either way, the killer put the hat back on his head after having been committed a murder. So that argument does not hold water. We know that Diego had 2 cloth gloves in his bags. Both of them are mismatched, meaning that, assuming that they each had a pair, there was a pair of gloves Diego owned that was never found. But while we're talking about gloves, I want to talk about the black gloves that were found in the apartment. We know that they were disposable kitchen gloves, and unfortunately we don't know where they came from because the officers didn't track the investigation that far back. However, Rose Bailey said that they did not come from Utaje, the sushi place where Jose and she worked. They did not come from the place that Jose Ibarra had access to. What we cannot rule out is the Bolton Dining Commons, the UGA dining facility where Diego worked. Why is that important? Because bringing the gloves home shows a step of premeditation. Who had access to do that? Diego. Why would he do that? Because he was planning to use the black gloves at some point. And speaking of gloves, why are there 3 of them found in the bushes? Jose has 2 hands, like everybody else, but there are 3 gloves, and they test all 3 and found presumptive blood on all 3 of them. What that suggests is that there are multiple pairs of hands wearing those gloves. Now, they did enter video evidence of Diego clocking in at work, but that video is not an alibi for Diego because his commute to work was only 10 minutes, and his clock-in time on February 22nd is 3:57, which is 6 hours after the murder. If anything, Diego's work schedule makes him more suspicious because the bus stop that he regularly takes to work is the one featured in the surveillance video near Saraswati's apartment. It is the same bus stop that the officer said they reviewed and never saw Diego. And we know that they should have seen Diego because he took that bus stop to get to work that day, which means the detectives never saw him because they missed him at least once, possibly more than once. We know that Diego's phone had no service, no location capabilities, and the agents testified that Jose's phone was a go-kart to Jose's race car. If Diego needed to use a phone with service, the phone that's already logged into his Facebook, Instagram, and Gmail, he would have taken Jose's. The state argued that Diego didn't act suspicious. Neither did Jose. Both of them complied with police commands. Both of them answered questions and were talking, laughing outside the apartment. Officer Cyan testified that the vibe amongst all the roommates was relaxed. They were smoking cigarettes. You can't assume anything good from Diego's behavior on February 23rd that you can't also attribute to Jose. But it goes beyond the possibility that Diego was involved. Diego himself, multiple times, confirms it. First, by threatening Stephanie Slayton. Now, Ms. Slayton has no incentive to lie, and the state did a lot of work trying to make her look uncredible. And I like that the state is not about shaming females until they're testifying in a way that complicates their evidence. Because they try to use her sexual relation with Diego to implicate her involvement. They've tried to shame her for celebrating her birthday. But the truth of the matter is she was scared and she came forward with the police anyway. She talked to them multiple times. She offered to let them download her phone, even though she was fearful of retaliation. Those are not the actions of someone who is making something up. In the context of that conversation that Slayton was talking about, she tells Diego, I know you're in that area a lot. You must have seen something. You should tell the police. And that's when he said, if you tell them that, like I was in the area and I might know something, I will tell them that you did it and then I will kill you too. Why is the two important? Because it's implying that he has already killed before. But Slayton is not the only one who has heard statements from Diego that implicate his involvement. Your Honor is aware that there are inmates who have heard Diego say that he was wearing the blue jacket on the day of the murder, that Jose threw it away in the dumpster, presumably for him. He told them that Jose didn't do it, and the police weren't looking carefully enough at the evidence. He put himself on the scene and told those inmates that he saw Laken Riley's body. Your Honor is obviously going to be thinking, well, how did Diego then not show up in the DNA evidence? He might have. We know that there were multiple male profiles on the straw. They said it couldn't be a blood relative because of the YSTR straw, but we know that Diego was not a YSTR comparison from the fingernails. So that could have been Diego on there. And as Ms. Hinkle said, the absence of Diego's evidence is not evidence of Diego's absence from this case. Some of the minor profiles on the gloves and the hat were not identified. And the true allele ratios that the state relies on said that the DNA was more likely to be Diego's than Arhannes'. Another theory of the case that is not excluded by the state's evidence is that Jose was an accomplice after the fact of the murder. Maybe it was him throwing away the jacket, as Diego said. Maybe he was covering up for his brother. Maybe one of the two men in the area went to the dumpster, and one went to the retainment pond at 9:46, which is where Joseph Clementi saw somebody standing. Maybe one of them dumped clothes in a dumpster behind the apartments, and maybe one dumped clothes in the woods, where Officer Krischer found clothes exactly in that area that were not tested because they didn't fit the simplistic narrative of the state. Maybe there were two men involved in covering up Laken Riley's body, which is why there were 3 gloves recovered in the bushes. 2 people wearing 2 gloves, and we just don't know what happened to the 4th. To explain why there are 2 rocks in this case. We know that Jose was looking for Diego on the morning of February 22nd, because Agent Hipkins testified that at 2:30 in the morning, there's a missed call from Jose to Diego. So there is some evidence that he was looking for Diego. The Spanish phrase in the 911 call could be Yo Tango, but it could also be the name Diego. That could be Jose saying his brother's name. Under that theory, of course, Jose would be guilty of tampering, but that theory does not prove that he was present or involved in the murder of Laken Riley. I want to speak last about 2 specific charges, aggravated assault with intent to rape and the peeping Tom charge. Their basis for concluding that the aggravated assault with intent to rape was the state of the clothes and the markings on her body. But Maxwell, the officer who found Laken Riley, testified that the area where he found Laken had vines and thorns. He testified about those catching on his uniform as he walked around looking for her. And they also, so it could have been that she was cut up by the vegetation of the area. We know that she unfortunately was dragged at some point because the scene where the blood is separate from where her body was found. So the scratches could have come from her being dragged to another area. And we also know it's unlikely to have been the scratches of her assailant from the fingernails, if that assailant was Jose, because when Daniela Stewart went to take his fingernail clippings the day after the murder, they were too short to take any clippings without having cut into the quick and being very painful. So it's unlikely to have been Jose's fingernails that caused those scratches. We also know that she had bloody marks on her ankles that didn't correspond to the wound, which suggests that somebody with bloody hands grabbed her ankles and used that to move her. And that could explain how her clothes were pulled up in that dragging position. We know that there was a struggle. We know that Miss Riley fought. Somehow her clothes could have ended up twisted in that struggle. And lastly, the intent to rape is a very specific intent. It's not just an intent to sexually assault someone. It's not just an intent to look at someone. It's not just an intent to expose their breasts. It has to be the intent to commit the legal definition of rape. And in this case, there's no evidence of trauma, according to Dr. DeMarco, of anything like that having happened or even attempted to happen. As far as the peeping Tom, the only part of the evidence I wanted to highlight for Your Honor at this point is that when Ms. Saraswati identified someone looking into her apartment, she said she never saw any part of his face, only the rim of his hat. So I think there's reasonable doubt that someone was actually able to look in. It may have just been the hat that was visible to Ms. Saraswati. Just one moment, Your Honor. Evidence that is subject to more than one interpretation is not proof beyond reasonable doubt. I would remind Your Honor that even if you think the alternative theories of the evidence are less likely, but they present any reasonable doubt, you would still be required to find Mr. Ibarra not guilty. We ask that Your Honor apply the exacting standard of the law to these facts and find Jose Ibarra not guilty. Thank you.
Ms. Ross?
So what we just heard really is magic pixie dust defense. It is not reasonable, it is not supported by any evidence, and it is desperate. And it is a combination of a break with reality and mischaracterization of the evidence. And I can just give you a few examples. They did not report, the GBI did not report that someone else's DNA who used to work at the crime lab was in any of these items of evidence. That was not the testimony at all. The testimony is that they have a validation for true allele. And if any amount, it was a 4% contributor, falls below their threshold, those are not reliable results, which is how they compensate for the known error rate of true allele. The GBI will not report results below the known error rate of true allele. Every single result in this case that is before Your Honor is reliable, reproducible, and validated. That's why they reported it. If it were not those things, they would not have reported it. And then let me give you another example of the desperation. Well, the straw could be Diego's. No, it can't. It wasn't a YSTR result with the straw. It was a true allele result. And it was this defendant's DNA on the straw with a mixture of someone who the expert testified is not a male relative. He could not be on that straw. So what we have heard is truly a mix between mischaracterization of the evidence and the magic pixie dust defense. There is no reasonable explanation for all of this evidence other than he is guilty of every single count in this indictment. And the you should acquit him because Tejasvi only saw the rim of the hat, that completely ignores that there is a head on the hat. That is desperate. And she said herself, he peeped. I see him peeping in my window in the body cam video. He is guilty of that, which shows his state of mind. And her aggravated assault intent to rape truly is what I thought it would be, which is he killed her, but he didn't try to rape her. Her underwear is torn. And I know Your Honor is an experienced jurist. There are multiple cases out there in the state of Georgia that disheveled clothing alone is enough to support a conviction for aggravated assault with intent to rape. But we have more than that because we have his motive 73 minutes before, and we have evidence of her clothes going in two separate directions. So those are, as my old trial partner used to say, just ink in the water. That's just to distract the court. The defendant, our evidence isn't based upon him having exclusive access to the phone. We never said that. She said that. What we have said is he had the phone that day, and there's no evidence to contradict that testimony. In order for you to find him not guilty, you would have to ignore all the evidence. They're saying, don't believe the DNA, it's not reliable. Don't believe the fingerprints, it's not reliable. And by the way, Tim Stewart covered in the the Albert fingerprint hearing that it is not unusual to not get an APHIS hit, but still do a hand-to-hand comparison and have a match. And his results, if you're at least a bit skeptical about them, and you shouldn't be based on his experience and his training and the methodology and the board that he created and how he explained how he got there, were blind peer reviewed by another completely different examiner who came to the same conclusion. This is reliable evidence, this is reliable forensic evidence, and then they're like, oh well, don't believe the digital evidence because you can't believe that either. There's no reason for you not to believe all the evidence in this case that's been put before you. And when you look at all of it together, it has only one reasonable explanation, is that he is guilty of everything in this indictment. And for the past week, Ms. Jackson and I have been fighting for Laken Riley every day in this courtroom. We're done. Our work is done. And we turn this case over to you to make a decision on all of this evidence in this case. And we are asking you in your decision to render a verdict that speaks the truth about what happened that day, on the 22nd day of February 2024, when this man took the life of an innocent woman, just going about her business, living her best life for no reason. It's senseless, and only you can end it. We're asking you to find him guilty of every single count in this indictment, to bring justice to Laken, her family, her friends, Tejasvi, and your entire community here in Athens. Thank you, Your Honor.
You all want to review the verdict form again. It's the same one you looked at yesterday, but you're welcome to look at it again.